Yes. So let me just introduce, then I'll give the floor to you. So I think
are you introducing a cricket team?
no,
Background demonstrates that you are introducing Virat Kohli. I don't know about Stephen. They may like it.
That would have been fun to have Virat Kohli with us, but yeah. So I take this opportunity to welcome you all for this session on comparative analysis of insider trading regulations in the EU and US. Um, we have with us Professor Marco Ventoruzzo, and we have with us Professor Mitra. Uh, I'd like to invite Professor Stephen Barnes to introduce Professor Marco. Yes.
So namaste to everyone and buongiorno to Milano. It's an honor for me to introduce my colleague and friend, Dr. Marco Ventoruzzo. Marco Ventoruzzo is truly, and I think it's appropriately put, given where he is in Italy, he is that Renaissance man, not only a Renaissance scholar, but that Renaissance man. And if you look at his deep bio, you get a really good idea of who he is as a scholar and as a person. He was educated in his undergraduate studies at Bocconi for his bachelor's degree in business and economics at the Universidad de Bocconi. And then he went on to do the equivalent of the JD, his undergraduate degree in graduate Studi di Milano. And then he did his LLM, his master's degree at Yale. And then he further did his PhD at Universidad de Sigli de Brescia, with my apologies for mispronouncing the beautiful language of Italian. But if you go on and you look at Dr. Ventoruzzo's impressive resume, you'll see that he's truly that worldwide scholar. He's been in Hamburg, he's been at Bangalore, he's been at the Max Planck Institute. And, you know, we had the great pleasure here at Penn State Law to have him in residence with us for well over 8 or 10 years, I believe, the founding of Penn State Law. And he's been at Tulane. He's been that person who's that truly international scholar. As a little anecdote, I will tell you that when he was with us at Penn State Law, when I would make an introduction about Penn State Law, and there would be, I usually had a PowerPoint of some 16 photos, and Marco was one of them. It was interesting, of all the faculty that I profile, especially when I was in Europe and in Latin America, he was the most visible and the most well-known faculty member, not because of his handsome looks, but because people know Marco Ventoruzzo, because he's one of the most well-published scholars in the legal field of his area, which includes company law, securities reg, international business transaction. And so it's really a pleasure for me to bring back my friend, Dr. Ventoruzzo, back to India, albeit virtually, to my hometown of Ahmedabad. So without any further ado, sir, Dr. Ventoruzzo, the form is yours.
Thank you very much, Steve. No, the only explanation for Steve's introduction is that it's night. He had to get up, so he's probably still a little bit dreaming. And so, and at the end of the day, the reality is that there is one accomplishment that I'm way more proud of the other things and never gets cited, which is being a scuba diving instructor. So, please take note for the next possible event. That's what I would prefer to talk about. But anyways, thank you very much, and thank you to my colleagues and friends to have invited me. The goal is to give you a sort of general overview of specifically insider trading prohibitions in Europe and in the United States, the two systems or families of systems I am more familiar with. And in this respect, my assumption will be that the overwhelming majority of the participants might have a very general, broad understanding of what insider trading is, but a lot of people are truly not familiar with how it is regulated in Europe and in the United States. If that's not the case, I see that we have a lot of participants, so it's hard, obviously, to have everybody speak, but feel free to signal to me if, again, I'm taking for granted things that are not known, or on the contrary, if I am going too slow or repeating things that you are already familiar with. But again,
Professor Marco, we will take questions
yes.
at the end of the session. So
Yes.
I'll ask the participants to direct all the questions to me, and then I'll ask those questions to you during the end of the session.
Perfect. Okay, so what is, and I will use the expression insider trading, which is probably at the end of the day the one that is most commonly understood around the world, even if in this very definition expression there are slightly different sometimes words or references that are made. But what is essentially insider trading? Insider trading is the prohibition to trade in listed securities, typically shares of a listed corporation, while in possession of confidential information that has not been made public and that is considered price sensitive. In other words, it is information that, if made public, it would significantly impact market prices. We will go much more in depth into this general definition, but just as a very general, broad idea, the concept is fairly straightforward. You are in possession of inside information, maybe because of your position, because you are the director of a listed corporation, because you are the lawyer, but also because you are an employee, or we will see and we will discuss a few cases. You cannot trade, you cannot operate. The economic idea underlying this prohibition is, obviously enough, if you have inside information, you could, so to speak, beat the market. The most accurate econometric studies on information efficiency of markets demonstrate, or at least concur to suggest, that while markets can be efficient in the so-called semi-strong way, as economists say, meaning that the market might be able to discount underlying fundamental economic information concerning the issuer that has been made public, surely markets are not efficient in a strong sense. In other words, if you, to put it very simply, if you do have inside information, you can make extra profits. Now, the first question that comes to mind, obviously, is why should this be prohibited? At the end of the day, for what is a good part of the recent history of financial markets, insider trading wasn't prohibited. The first insider trading enforcement actions in the United States date back to basically the 1960s of the last century. In most European countries, insider trading was introduced around the 1980s. And for a fairly long period of time, there was no insider trading prohibition. As a matter of fact, being able to use inside information to speculate was considered part of your benefits as the manager of a corporation. There's a very famous anecdote. It's kind of unclear how true it is, but you know that the first chairman of the SEC, the Securities and Exchange Commission in the United States, was the father of President Kennedy, was Joseph Kennedy. And he was known for having profited from insider trading when it wasn't prohibited, right? And so when he was appointed, someone asked Franklin Roosevelt, why did you appoint a crook as chairman of the SEC? And Roosevelt said, well, you need a thief to catch another one. No? So this is just to say that, you know, even the social stigma that it's today associated with insider trading wasn't there. Some people say, well, insider trading at the end of the day is victimless. If I have inside information that tells me that the shares are worth more or less, and I use it, on the other side, I find someone who is willing to sell or buy. So in a way, there is not really a damage I'm causing. On the other hand, also, you know, some commentators, and not only back in the 1960s and 70s, even today, argue, you know, insiders, in fact, have an important function because they contribute to what is called price discovery. By trading, they send signals to the market that are relevant. So let me give you an example. I am the director of a corporation. I know the corporation has a problem that has not come out yet, and I start selling shares. Some people say, well, you know, you're not maybe disclosing this entire information, but the very fact that you're selling tells something to the market. If you prohibit this, you know, this kind of effect won't be there. But notwithstanding these objections, long story short, in virtually all modern legal systems, insider is prohibited. It is sanctioned with both criminal and administrative sanctions, and I will come back to this. And the reason, again, if we want to try to extrapolate, is twofold. There are both efficiency and equitable reasons, and are connected in an interesting way here. Because the basic problem is that the vast majority of investors think that the fact that someone can gain more simply by exploiting their access to information, not due to their work in terms of analysis, of studying the market, but simply because they do have a particular role, it's considered unethical. It's considered unfair. And if a sufficient number of investors think that this is unfair, unjust, they will, more likely than not, just exit the market. So markets will be less efficient and less liquid. And so you somehow see, as it is often the case, obviously, a connection between what we might call, you know, fairness or equity considerations and efficiency consideration. Now, I'm not here, obviously, trying to discuss in any detail how well-grounded these rationales are. This is probably somehow more an issue for economists, but just to give a little bit of sense of what might be the underlying economic and policy reasons, and how this was treated throughout the years. Now, if this is, fairly clear, and again, we will be able to come back to this toward the end. My idea was to split the rest of the discussion in two parts. One, I would like to talk about how this problem is addressed in the European Union, and secondly, compare this with the United States. Okay, and if you I apologize 1 second, I take off my blazer because it's kind of warm today here. Okay, so if we start from Europe, in some ways, we could say that Europe is a second comer to the regulation of insider trading. As I briefly mentioned before, the very first applications, the very first enforcement actions based on insider trading date back to the 1960s in the United States. It took, I would say, roughly a couple of decades for Europe to introduce insider trading rules. However, as hopefully will become clear at the end of the discussion, the European regulation is today, I believe, way more strict and also, at least I would say, more rational in its design. Now, we might disagree with the rigidity of the European approach. We might think that that's too strict, it's too severe, but unquestionably, the system is a little bit more straightforward. And what's the basis of this system? It's in a way very simple, because it's a principle called parity of information. So the idea and the ambition is to ensure a virtual level playing field among all investors with respect to price-sensitive information. To understand a little bit more technically how this works, let me walk you through a couple of definitions in the European regulation. And as a side note, please note, again, I guess several of you are aware, but the different state members of the European Union, they all have their own jurisdiction. And needless to say, among themselves, are more different than US states. They are more different linguistically, culturally, they are more different in terms of their legal traditions. However, the European Union harmonizes certain area of the law. Financial markets is clearly one of the most harmonized fields. And insider trading in particular, what we call market abuse, is governed by a regulation which is the same in all the states. So we can just look at this one source, and this one source will basically tell you how it works all over Europe. Now, what is, first of all, the definition of inside information? The definition is information of a precise nature which has not been made public, relating directly or indirectly one or more issuers or one or more securities, financial instruments, and which, if made public, would likely have a significant effect on the prices of the securities. So, precise, not public, concerning an issuer or the securities of an issuer, and last but not least, price sensitives, capable of affecting significantly the prices of the shares. These are the basic elements. And each one of them raises interpretative questions and a number of issues. Of course, we do not have the time to go into all of them, but I will try to make at least 3 or 4 examples that hopefully offer, in a somehow more engaging way, a sense of the problems that this definition might raise. However, if we put it for 1 second in the back burner, the definition, let me also walk you through the overall structure of the prohibition in more detail. Now, if you have inside information, you cannot trade, period. There are very, very, very limited exceptions. And most importantly, it's not particularly relevant how you acquire the information, whether you have obtained the information because of your profession, because of your position on the governing bodies of an issuer, because you were driving a taxi and overheard a conversation, because you were at the stadium sitting next to the executive of it. If you have inside information, you do not trade. And if you do trade, there might be, again, some, as we will see in a second, very, very serious sanctions. Also keep in mind that nowadays, also frankly, you know, in countries such as Italy, the supervising authorities have very effective enforcement tools. I have seen cases in which they, incriminate someone for insider trading by tracing their cell phones and seeing that they were having coffee with someone and after a little bit. So, what I tell my students is simply don't do it. Okay, they will catch you. But there is not only the prohibition to trade, but there is also another very important part of this system, which is an active duty, a duty to disclose. The European regulation says that as soon as the issuer, the corporation, the listed entity, has inside information, is aware, for example, they are negotiating a merger and they've reached an agreement. There is an important arbitration that has been lost concerning a patent. As soon as the corporation is aware of something that might affect the market prices, to put it roughly, they must disclose it to the entire market. So as you can see, this notion of inside information is really a coin with 2 faces. On the one hand, if you have inside information, you cannot trade. But on the other hand, especially the issuer and its directors, if they have inside information, they might disclose it. So by disclosing it, they make it public. The information will no longer be confidential and everybody will be allowed to trade. Okay? Now, if you think about it, this clearly enough is the underlying idea is total parity of information. No one can trade and the issuer might disclose any price sensitive event. You might also wonder, well, why is there a prohibition of insider trading if the issuer must make public the information as soon as they have it? Because in principle, if they have an obligation to make it public and this obligation is fulfilled, there wouldn't be inside information. Well, of course, it's necessary because on the one hand, the issuer might not comply, but also because there's another thing that I think it's worth mentioning, maybe in a couple of also email exchanges with Yash, we touched upon this. Because the issuer might have situations in which disclosing the information would be a very serious damage for the issuer and for the investors. Example, you're negotiating a merger. The information in itself is price sensitive, but if you disclose it now, there's a significant risk that the negotiations will not go through. So the consequence of this is that there are certain conditions under which the issuer can delay the disclosure of the information by demonstrating certain things, that it would be there will be a prejudice in disclosing the information, that the confidentiality can be ensured, and so on. I mean, we're not probably so interested in these technicalities, but in these cases, and issuers do use this option quite a lot. In these cases, as you can see, there is a time frame in which there is an inside information that has, however, not been made public yet, and so there is a possibility of insider trading. Now, if the overall structure is very clear, let me try to throw on the table 2 or 3 questions that have come up both in case law and also in administrative actions, or have been discussed by scholars, which hopefully give a sense of better sense, also a more concrete sense of the issue. The issue. Let me start with a very simple one. You know, a lot of business events, corporate events, obviously enough, do not happen in a singularity, in a single moment in time, but they are part of a process, of a procedure. At what time of these kind of procedures something becomes an information acquires the requirements for inside information? This is not a particularly complex question from a theoretical perspective, because, you know, the definition is relatively straightforward. It needs to be precise enough. It needs to concern the issuer of the securities. It needs to be not public and capable of affecting prices. But in concretely, practically, it's often hard to tell exactly when. And now I will tell you one thing that, for reasons that somehow elude me, the most European courts would not explicitly say so, or even say that that's not the case. But I think that they're not really saying what they in fact do. To me, the best way to explain it is to use the American concept of probability magnitude test. In other words, when you are considering the possible impact of a certain information concerning an event that has not been, something that is not final yet, you have to consider how likely are the different future scenarios and how relevant they would be in terms of price. So, for example, you are, and it happened to me a lot of times, you are negotiating a merger, or you are considering to launch a tender offer. Well, even if the transaction in itself is very important economically, at the very beginning, when everything is still up in the air, you're just talking, you're just trying to see if there's any possible common ground, if it's feasible economically, financially. You know, obviously, at the minimum, the information is not precise enough. It's too uncertain in terms of probability of what will happen to have an impact. Even if you would say to the market, well, we are talking with this corporation about a possible joint venture, when it's so vague, it's likely to not have a very significant impact. Of course, however, you cannot say that in the abstract. You always have to look at the single and the specific facts. But clearly enough, as you walk through, for example, these procedures, these negotiations, it comes a point when it starts becoming sufficiently likely that something will happen to become price sensitive. So you cannot come up with a hard and fast rule with a you know, it's not a black and white issue. You always have to look at all the circumstances, but that is the idea. And for example, it came up in cases where a director wanted to resign, and so the question becomes, well, at what point, how formal the resignation has to be before you can actually have inside information. Another interesting question, which is somehow related to the question of whether it's sufficient to possess the information or you also have to actively use the information to commit insider trading, is the following. And I will, you know, I believe that it would be too complicated to have people to try to answer or volunteer something, but I will still let it linger just for 3 seconds. Now, imagine that you have information about a corporation that will make the volatility of the price increase. In other words, you know that when this will become public, the market price will start moving, but you do not know the direction. You don't know if the price will go up or will go down. Now, this might seem like a kind of weird possibility, but it's not. There are situations in which a financial analyst, someone understands that something will make the prices of that particular issue more volatile, but is not sure whether they will go up and down. Now, is this inside information? Is this precise enough? Or you need to be able to predict the direction in which the price will move. Some commentators in the past especially have said, well, you need to be able to tell how the price will move, because at the end of the day, otherwise you would not be able to make a profit. But that's technically not true, because just knowing that the prices will move more extensively or more actively, you still can speculate with derivatives. So the European Court of Justice, for example, has, in a fairly famous case, decided that, you know, being aware to predict the direction of prices is not an element of the inside information. As long as you know that it will affect the market prices, that's sufficient. And this one decision, for example, is one of a series of decisions that have somehow broadened the idea of inside information. Let me give you probably one of my favorite examples and cases, which you know, really I think shows how this issue is somehow at the border, you know, not only with law, economics, but in a way as also a philosophical or psychological component. The problem is called the problem of the self-insider. What is this? Well, when we talk about information, just in common parlance, I think we imagine something, a piece of knowledge that comes from the outside and that enriches our knowledge about the world. But it's something that I take from the outside. It's not, generally speaking, from my own perspective, a decision that I have taken. Even just in our everyday experience, no, we say, well, you know, I've been informed that John wants to buy an apartment. And then I say, well, I have decided to buy an apartment. Okay. Now, can an inside information, however, also be something that I have decided, so to speak, internally? the very fact that I want to do something in the future can be insider trading, question mark. Concrete example, otherwise it sounds too theoretical. And I'm mentioning this because it was a very important Italian case, very discussed, in which, in fact, the Italian equivalent of the SEC took a very, I think, an excessively broad position, which I think is very questionable. And here, what the case was, and I oversimplify it, and also there are, I have to say, some additional factual details that make the rigidity of the SEC somehow understandable. But to concentrate on the interesting general question, I will somehow simplify the facts. Imagine that I'm the controlling shareholder of a corporation, and I decide that in 20 days from now, I will launch a tender offer on all the shares to bring the corporation private. That is my own decision. Of course, if the market would know that I have decided to launch a tender offer, this will likely have an effect on the market prices. But does it mean that my knowledge, or more precisely awareness of the fact that I intend to launch a tender offer in a few weeks, represents inside information, meaning that from now to the moment when I launch the tender offer, I cannot trade, I cannot buy additional shares? This is a very tricky question because, well, on the one hand, if you argue that that's inside information, you might say, well, that's basically inapplicable, because how can people know that you have decided something? But of course, the reality is that when you launch a tender offer, it's not that you wake up one morning and you say, well, you know what, I buy a new pair of shoes. No, you have to talk to bankers, you have to talk to, so, the information about your decision starts going around somehow. So, long story short, I think that generally speaking, information concerning your own decisions to operate, to trade, should not be constitute inside information and be punishable if you trade based on that. Also, because if you think about it, otherwise you couldn't. There's always a strategy behind, or almost always behind trading. If I buy shares today because maybe I think that from now to next week the price will go up, and then I believe that it will go down. So I already know that after that I will want to sell. So it really becomes, I think, potentially extremely broad. However, I am also willing to recognize there are also some, textual elements in the regulation that might support this position, but I will not obviously go into a textual analysis. I will just, discuss the concepts. However, I also have to admit there are some situations that are not so black and white, or in which this notion of self-insider might be more relevant. And again, let me give you a peculiar example. A very charismatic CEO has decided to step down. And she knows that when she will step down, market prices will take a dip, will go down, because she's considered this great genius of that one corporation. But she's sick of it all. She's made enough money. She wants to go to live in Aruba. And so she knows that in 3 weeks, she will resign. It's just a decision inside her, in what the Latins used to call the internal forum. Can she sell a few of her shares before going public with her resignation and before the price decrease. Well, you know, if you look at it, this is very similar to the other example I gave. But here, I believe most of us, even just ethically, would not like it so much. You know, here you really have, while in the other sense, where the inside information we were talking about was specifically concerning, let me say, trading on the shares, operating on the market. Here, there's something that is a little bit more ugly. It sounds like she's exploiting the fact that she knows. So again, unfortunately or fortunately, we probably don't have the time now to discuss all the different technicalities and implications of this, but I just wanted to give you this one example, this one problem to illustrate the complexity of the issue. You know, same example that I just made, which somehow actually was relevant even in in a few cases. But imagine that it's not that the CEO has decided to retire, but has a very serious illness. And at that point, you have also an issue of privacy. No, so again. Self-insider, I think it's one of the forefronts of this matter, and I think it's an interesting and fun topic. Now, you know, with these very broad strokes, I hope I have given you a sense of how it works in Europe. Total parity of information, a pretty broad notion of inside information. You have inside information no matter how you got it. You cannot trade, you cannot operate. You also cannot give tips to other investors or disclose the information to other investors, obviously enough. No? On the other hand, the issuer must disclose it, generally speaking, as soon as possible. Okay? Just to give a sense of what it means as soon as possible, I've seen sanctions inflicted because, for example, an issuer waited 4 days before disclosing an information, okay? But on those bases, let me give you one of my, once again, favorite hypothetical, which I think helps us to transition to the United States. Now, imagine that your friend is a taxi driver, and he's driving a couple of, clearly enough, important executives of a listed corporation from the headquarters of the corporation to the airport. And he overhears a conversation that clearly suggests something on the company, implicating that the market price will have certain effect. They are about to disclose and release this great new product. They are about to patent this new vaccine for COVID-19. So whatever it is, he overhears the conversation, understands that something big is going to happen. And based on that, he decides to buy shares. Would he be guilty of insider trading? Well, in Europe, very likely yes. I would say almost certainly yes. In the US, very likely not. And this is, I think, one of the most interesting differences. And let me, briefly try to illustrate why. Now, first of all, and I think this is fascinating, technically speaking, the United States does not have an explicit statutory regulation of insider trading. The closest you get is Section 16B of the Securities and Exchange Act, which, however, is a very, very peculiar, I would say almost bizarre provision that basically forces certain categories of insiders, but only certain categories, to disgorge profits that are made by buying and selling shares in a short period of time. But it's a very, very, at best, it's a very, very peculiar case of a sort of presumption of insider trading. So let's leave section 16b to the side, even if practically speaking has a certain relevance. But if you look at the securities laws in the US, there is not really an ad hoc regulation of insider trading. Insider trading actions, both criminal, administrative, and sometimes civil actions, are in fact based on section 10b-5 of the Securities and Exchange Act of 1934, which is a very broad, very vague, very general provision. It's, in fact, as you probably know, it's called the catch-all anti-fraud provision that doesn't really, regulates with any degree of precision this. It basically, and again, I'm basically trashing the provision, but it basically says it's illegal to make misrepresentations and omissions when communicating about financial instruments and dealing in financial instruments. I mean, they would fail me at a securities regulation exam, but more or less it's what it says. So it's a very broad provision that clearly in the 1930s was not written having in mind insider trading. But then, as markets develop, sensitivities changes, the SEC starts saying, you know what, it's not right that some people just profit out of their position. Let's do something about it. So in the 1960s, there is this very famous first case, which almost sounds like a story from a movie, in the sense that there was some natural gas that was found in an area, and one person goes around trying to buy land without disclosing the information. So again, I won't go into the details, but it's a fairly straightforward classical case of insider trading. The SEC steps in and uses this very general provision to basically say, well, if you trade without disclosing inside information, you're doing something wrong. You're violating the Securities and Exchange Act. And in this first decision, the SEC, in fact, adopts parity of information, the very strict and broad notion that is used in Europe that I mentioned before, okay? However, a few years later, in the 1980s, there is another super famous case that you might have heard about, which is called Chiarella. The name is actually of Italian origin, so probably in Italy we would say Chiarella, but in the US they say Chiarella. And Chiarella is another fascinating story. Again, very briefly, just to give you a sense of the facts. This guy, Chiarella, was the employee of a printing company. And the job of this printing company was to print financial documents, including prospectuses for tender offers, registration statements, and so forth. Now, they happen to be printing a document saying that Corporation A will launch a tender offer on Corporation B. And in fact, the names of the parties were erased, but Chiarella kind of starts thinking about it, maybe tampering a little bit with the document, and figures out who they're about to buy. And so to decide, he buys shares. He's caught, the SEC or the Department of Justice brings an action. This is also criminal, so he receives a criminal sanction, but the case goes all the way up to the Supreme Court. And basically the Supreme Court, in a way, if you want, got cold feet on this, because they say, well, wait a minute, this is too broad. You could have all sorts of people that are prevented from trading because they figure out, so they again, obviously oversimplifying it, but they have the sense that, especially considering that this is criminal now, so you need to be somehow restrained now in how you interpret the rules. This is too broad. And so they come up with this, in a way, fascinating, but also very peculiar theory, doctrine, which is the fiduciary duty-based theory of insider trading. The judgment, I think, is, as it is often the case, very well written, very interesting. there are clearly some possible bases for this. However, and this is fairly shared about commentators, it's really an invention. There is no suggestion in the law, in the statute, saying that you need fiduciary duties to commit insider trading. What is the idea of the Supreme Court in, again, a nutshell? Is, well, okay, we understand trading in possession of inside information is wrong. However, to commit the crime, the violation, you must be in a fiduciary relationship with the source of the information, and it's a little bit ambiguous, but and or with the corporation to which the information is related. What is the problem here? The problem is that the notion of fiduciary duties, while having a few centuries of development in the common law, it's still very ambiguous. We have some very clear cases of primary insiders. If you are the director of a corporation, if you are a top executive, if you are one of the lawyers, surely enough, you are a fiduciary. There is a fiduciary relationship with the corporation and the source of the information. But apart from those figures, it very easily becomes muddy. And additionally, there are a lot of people that still obtain the information because of their position, but that cannot be considered insiders, fiduciaries. And so the prohibition would not apply. One of the cases I find funny, and I cite to my wife, is called Chestnut. I think, if I remember correctly, it goes back to the 1980s or 90s. And basically, it said there was a case in which I think the husband shared some information with the wife, and the court said a relationship between husband and wife is not a fiduciary relationship. Doesn't create fiduciary, which is interesting because in a way, you know, if you think about the history of fiduciary duties, they have primarily, it's the case where you have an agent managing the assets of a principal. Now, so you might argue, but apart from the fact that it's just simply too funny to say to, you know, your wife, you know, there's no fiduciary relationship. But this, I think, gives you the sense of how tricky it can be to establish whether there is a fiduciary relationship. In fact, so tricky that the Supreme Court itself, and this is often a pendulum that swings back and forth, a few years after Ciorella, they said, well, you know, we were maybe too easy on insider trading. Why? Because they had another famous case called O'Hagan. And O'Hagan was a lawyer, but was not working with the issuer, with the corporation involved in this transaction. He was just at the same office. But walking by a meeting room, he kind of overhears something, and he trades. Well, in that situation, because he was not the lawyer of the issuer, you couldn't say that he had a fiduciary duty. So the Supreme Court, in this case, came up with yet another theory, which is called the Misappropriation Theory, which says, well, on the one hand, this guy had a fiduciary relationship with the firm, but by capturing this information, he misappropriated that. So this other additional theory requires that, well, you still can commit insider trading if you obtain information somehow illegally. And it's interesting because based on that, for example, if you are a hacker that hack into a computer and you get information and then you trade, that's how in the United States they would hook you. With the Parity of Information approach in Europe, you don't need to go into these somehow convoluted theories. You have the inside information, you cannot trade, period. So as it is often the case in the US, and as it is often the case with prime movers in certain areas of the law, the overall framework in the US is frankly very baroque, because there has been this constant work of hide and seek, in a way, between the federal legislature, the courts, prosecutors, the SEC, the parties. And so most of insider trading actions are based on these doctrines based in case law that are not often crystal clear, such as the fiduciary duty theory and the misappropriation theory. In addition, in the US, there's not a general obligation to disclose all price-sensitive information for the issuer. You get very close to that because you do have a very extensive list of specific things you have to disclose, and you also have a general duty to update previous information. So to the extent you have published a financial statement and something happens that might change some of the the picture that the financial statement indicates, you have in principle a duty to disclose it. But even the duty to disclose is not on paper as pervasive as in the market abuse regulation. So as you can see, if we go back to our little taxi driver case, you could probably say that in the US, he would be allowed to trade. Why? Because the taxi driver does not have a fiduciary relationship with the corporation of the employees, and he's not misappropriating the information. He's just sitting there and hears it. If the executives would have forgotten a briefcase and he would have forcefully opened it and looked at some papers, then you might argue that there's misappropriation. But I think that that's an interesting, if you want, distinction between Europe and US, because again, it also tells you something probably at more sociological level about the approaches of these two different systems. If I have another 3 minutes, I might conclude with one additional point, but I can also stop here to leave room for Q&As. Just let me know what's best.
If you can do it in a minute or so, and then we can go to Mitra sir to discuss Indian position. Yeah.
Sure. It's just I literally throw it on the table. Insider trading is prohibited both criminally and with administrative sanctions. So you can go to jail, and you can have fines that are both criminal and administrative. Now, a lot of actions are only administrative because, sometimes it's faster, it's quicker, there are not some certain elements that might be necessary for the crime. However, the administrative sanctions for insider trading are huge. They are very easily millions of dollars or euros. And in addition to that, even the administrative action might have as a consequence that, for example, you would be barred from being a director of a corporation for 5 years. So measures that somehow affect your freedom. For these reasons, there's a line of cases, to some extent also in the US, but also in Europe, with the European Court of Human Rights, arguing that the administrative sanctions in this case are in fact criminal in nature. So independently from the formal qualification of these sanctions, they should be treated as criminal sanctions with all the protections for the accused in that respect. This is a very interesting development. One of the most famous cases in the European Court of Human Rights, in fact, affected a fairly famous Italian lawyer. And, when I started studying insider trading now, probably 20 years ago, I would have never thought that it would have become an issue of human rights, but that's the case. And so that's just the last issue that I wanted to throw on the table, but I've spoken too much, so apologies, and let me stop here.
Thank you very much for that insightful discussion. I would like to ask Dr. Puri Purkrial, Dean and Director, Institute of Nirma University, to introduce Mitra sir. And then we can.
Thank you, Yash. Good afternoon, friends. It is indeed an honor for us to have with us Professor Anil Mitra. Professor Mitra, a legal educationist par excellence, a man with a great vision and humor. Professor Mitra has more than 5 decades of teaching journey, and he has played many roles. Professor Mitra has been an academician, a researcher, educational planner, a program designer, institution builder, a legal advisor, legal draftsman, and has been the Vice Chancellor of National Law School of India, University Bangalore, was the founding Vice Chancellor of National Law University, Jodhpur, has also been a Chancellor of KIT University, and very actively engaged in the legal education reforms post 2010. So what we call is the fourth generation reforms in legal education. Professor Mitra has been an advisor to SEBI, to Competition Commission of India, has headed many committees for the financial reforms in India, and has also been associated with the law firm called Fox Mandel. It is indeed a great honor, Professor Mitra, to have you with us, and I'm not taking much of your time. Over to you, Professor Mitra. Thank you. Sir, kindly unmute yourself.
I am really grateful to Marco for laying down a strong foundation of insider trading. The concept I will take 2 minutes for concept development and the philosophy. The concept is insider trading, not inside information trading. That means concept allows inside information, because without inside information, market will not develop. So it is not that inside informations are not to be traded. Insider shall not trade. So definition of insider extremely important. Okay. So definition of insider, and obviously trade is also very important. What is that called trade? Right? Now, obviously, whole thing is fundamentally related to inside informations. Okay. Now, why these inside informations are important? For the purpose of trade, why these inside informations are important? Marcos has developed a European concept of what is called misdemeanor, misstatement, misappropriation. So he has taken the thesis of misappropriation. Now, if you look at that, before we go and analyze the concept of misappropriation, let us see why. What is the market philosophy? Market philosophy is that the two persons who are buyer and the seller, they must have asymmetry of information. If there is no asymmetry of information, market cannot be developed. So only if I have to trade on something, I have some information, and you are selling that, you have another information, we do not have information asymmetry, then there cannot be a question of demand and supply interplay, right? I will have misconceived demand and you have a misconstrued supply. So this misconceived and misconstrued demand and supply doesn't give market, doesn't create the market facility. Market, therefore, the concept of market is itself very complicated. Okay, one of the fundamental of the market is that market must be completely free of anything superimposition by buyer and the seller. There must be the buyer's market, there must be the seller's market. Okay, so it must be a kind of an asymmetry of information on which both the parties are going to trade. The second is that, which is extremely important, is called now common law concept of no unjust enrichment. No one can have any unjust enrichment. You cannot have unjust enrichment at my cost. I cannot have unjust enrichment at your cost. Buyer and the seller must not have unjust enrichment. Now that is what is considered as unpublished price sensitive information. Unpublished price sensitive information. if the information is published. So definition of publication is extremely important. What do we mean by publish? Now, I and you, we are buying and selling, and information that you have, you are disclosing to me, not to the third party. Is it a price sensitive information being unpublished or published? So that would be the question. Now, his motor driver analogy, it is not an analogy, there is a living case in India, very interesting case. This unpublished price sensitive information, therefore, plays the, as he says, no ground playing conditions very disturbed. You do not have equal ground playing condition, ground playing conditions are disturbed. Incidentally, I think there is very less insider trading in India. Otherwise, people sitting in Ahmedabad on 24th of February calling this type of conferences or lecture is unthinkable, because you must not have used your inside information that you have. 24th is that you have world's largest stadium and one of the largest democracies prime minister having a stadium in his name being inaugurated by the president of India with a cricket game, living cricket game, and you are still sitting in this front of a black box. It's a kind of stupid black box. So we are all stupid in front of a stupid black box while everything is funny things are going outside, isn't it? So perhaps this inside information is price sensitive. It's very price sensitive because all of you are out from the market. Therefore, you did not demand your ticket. Okay, so very price sensitive. Now, in that situation, we are discussing today the price sensitive information which is unpublished. So what is published and what is unpublished? Marco, I think that you are tired after 1 hour, 10 minutes, and therefore you want to take a break, right? And I started when you were in break.
No,
I started on your.
I'm fine.
I started
I'm fine.
on your foundation. Okay, so I said that market must have asymmetry of information between the buyers and the seller. I also said that the English concept is called there should be no unjust enrichment by either by the buyer or by the seller if there is a market worthy name. And no one can prevent unpublished price sensitive information. No one in the world. No one can prevent information. Okay? Parliament by an act cannot stop information generation. Today, information generation is so automatic and is so calculated and quantitative. Now, price sensitive information is plenty. Is plenty. So it is not that price sensitive information cannot be marketed. Price sensitive information can be marketed. What cannot be marketed in India is that the person who is having the knowledge, he is put outside the market. He is rusticated from the market, as a matter of fact. Okay. So it is insider trading, not inside information trading. Now, responsibility of fair disclosure. The person, now this is very interesting. Now, even in our civil law, I mean, European civil law is slightly different. Our civil law, there is a presumption that anyone going to the court has to prove his case. Now, if I go to the court and say that there is a price sensitive information remaining with my seller of the security, I have to prove. Now, in this case, English common law rule of evidence has been deviated. We have now a law where it says that there is a square responsibility lies on the person that there has been a disclosure. If I have price sensitive information, I have the duty to fair disclosure. Okay, I have to prove to the court that there has been fair disclosure. I made a fair disclosure. Now, this is extremely important for us. So I think the market philosophy is based upon these 5 concepts or 4 concepts. And since we are common law, we actually give emphasis on unjust enrichment. Okay. Now, there has been a recent change in our law, legal positions. In India, like in US, we had actually information insider trading, both a criminal law, matter of criminal law. It is a corporate crime. It was a corporate crime, but Section 195 of the Companies Act of 2013. Okay, and it continued. So it was a crime, and punishment was 5 years rigorous imprisonment. Okay, and or fine. Now with that we have added what? We have added by this act, by SEBI has added by 15G, added disgorgement. That means that if you have earned a profit by virtue of your inside information, whatever profit you have made, 3 times that profit, you are bound to account for now. Right? Am I clear? So that is one, that the source of profit is taken out. And then, of course, there is a kind of a penalty imposed, but no fine. Fine is a criminal law. Now, 2018, we have amended our Companies Act, and therefore that insider trading as a crime is now off. Am I clear? Though it has been said in the preface of the amendment that SEBI Act has taken squarely the responsibility of insider trading. SEBI has taken complete control of insider trading. Therefore, criminal law is amended. Company law for the purpose of amending the criminal law, IPC, is now not required. And therefore, this is no longer a corporate offense. So 295 or 190, sorry, not 295, 195, section 195 has been amended, completely taken up. Now, this is the most common, I think, is that. The second thing is that I take his case, that motor driver case. Very interesting in India, that a company is managing, and the company I will not name the name of the company as the managing director. I will not take the name, but perhaps if you read, you will get this case. A managing director, after his corporate meeting, board of governors, board of directors meeting, he was coming out, and he went on board his car, his cab, his driver, company driver. There is no question of outsider, all insider. And he, accompanied by another director, was going through the car, and they were discussing about how they are going to take over another company. What would be the methodology to be followed in another company to take over? It was overheard by that driver. The driver, in the night, he said, "Look, I always drive my managing director. I know all the information about that. Today, he said this. He told his wife, not to say anybody, not to any other person. So wife then had a conversation with the wife of a broker. That our company, wife now in saying, said our company is going to buy that company. Now the broker's wife told to the broker advised his client to buy so much of share. Now in India, 2 things would be now in question. One is insider trading. The other one is takeover code. Okay, if it is a takeover code, if you buy 5% and above, then takeover is necessary. Then public disclosure is necessary. You have to give a public notice. You know that, right? So if I have to buy 5% and more, I have to give a public disclosure. But if it is 5% and less than 5%, I need not, I am not coming under takeover code at all. So I have to see only insider trading, this prohibition. What is the law of insider trading? Now, for those who are in India, insider trading law is, today we are marching almost nearer and nearer to US position. Now, when we globalize law, what do you mean by globalization? The word globalization is called, the market is globalized by the rural framework, by the legal framework. Market is globalized by the framework of law. It is legal globalization. And in that process, we are also moving towards the same position and moving towards gradually, because in India, when I started, when I was with SEBI for quite some time, I must have worked for them for almost a decade. All these regulations are drafted by some of us. So therefore, that when we are moving towards that, at that time, it was 2000, 2001, 2002, 2003. We have moved far. Now it is 2020. Now, many of the thought of that time is now not necessary. At that time, in one of my report, I must have suggested that in India, insider trading prohibition is funny, because there is only insider trading, there is no outsider trading. Why I said that? I said share market is not corporatized. It is by the broker, for the broker, and of the broker. Okay, it is by the broker, for the broker, and of the broker. And therefore, if share market has to be the market, capital market, and it is cornered by one section, the broker, middle people are broker intermediaries, then in that case, what can remain as outsider? There is no outsider trading. Only insider people are trading. And they have two power. One power is buying spot for the client. The other power is that they are jobbers and brokers both. They can buy for themselves as well. You understand that? Even today, a broker has got two roles. He can buy and sell for him. He can buy and sell for you, all of us. Okay. So he has about, say, today it is a spot buy, because future is now not there. So spot buy and sell. If it is a spot buy and sell, they get about 3 hours to settle their accounts. That means you require 3 hours to declare whether this buy is your buy or this buy is your client's buy. And that 3 hours is quite enough to play with the inside informations. Therefore, we have to understand that insider trading in India is it has in the last about 2 decades it has developed quite a bit, but we have a lot of distinction between the European system and India, and we are nearer to American system than European system. As for example, even if we do not have present day that it is an offense, but there is ED, there is, if you have foreign institutional investors, ED is involved, and that is an offense, that is a crime. So, when you have market complexes, shareholder classifications, we have shareholder classifications, gradations of shareholding, okay, shareholders classification. And as the shareholders classifications are there, now you have this classification be distorted, and at that point of time, there is also offense created. So ED has the jurisdiction for trying that. Now that all means that insider trading in India now has become a complicated phenomenon. Now, what is the law involved? Now, running thoroughly, the only law is just like US. Only law, legal section act is section 15G. Okay, that is the law. But we have delegated legislations. So we have regulations, insider trading prohibition regulation, which has got regulation 3, regulation 4, regulation 7, regulation 5, regulation 3459. Okay, so these regulations are there. Now, I said important thing is here, who are insider? When you say insider, who are insiders? That is the question. Now, law says insider means any person who is a connected person with either officers or the directors or person in contractual or fiduciary or employment relation, or with director, officer, employee directly or indirectly accessible to UPSI. Now, as I said, when you have driver communicating to the broker's wife, through broker's wife to the broker, and then there was insider trading indulged in. Now, do you think that it is an insider trading? Now, our definition, therefore, is not the price sensitive information so much. It is relating to the definition of insider. Now, therefore, who is insider? Any person connected with all these categories of people. So you are broadly make large, so that any person connected with the market system, as in US, okay, connected with the system and disturbing the market, creating asymmetry of information, shall be subjected to the civil offense. I will call it mildly a regulatory offense of insider trading. Now, connected persons, we understand here it is dealing with the connected person. His wife, that wife, then the broker, it reached to the broker. So broker is an intermediary. So these are all connected persons. We understand that. Now, connected persons, if I say insider, do you mean a broader category of insider or smaller category of insider and then a larger category? That means a penumbra of insider is there, or all are in the same insider. Now in India, Indian courts take a kind of an attitude of penumbra meaning and thick meaning. Now, if it is found that if a director is involved, or the CEO is involved, or an employee 2 grade lower than the managing director, these people are involved, or you see the brokers, intermediaries of the capital market is involved, there the rule is inflicted very strictly. Whereas if it comes to the penumbra, we find that 1/3 of the profit, because it is always difficult to imagine what is the profit you have earned out of inside information trading. So what is the profit? So 3 times the profit is recovered. These 3 times the profit are never recovered from, or wanted to be recovered from, this penumbra meaning. So it is a thick meaning and a penumbra meaning of the term. What is that price sensitive information? Let us see first. Price sensitive information generated from where? As Marcos has very clearly said, price sensitive means what? It's a probability. So you have to have a kind of probability situation that if this information been available to the buyer or the seller, the buyer would have given a better price, or seller would have demanded a better price. So this is called price sensitive. That means it has to have a kind of ascendancy or descendancy of the price structure. Now, today, the quantitative system and your quantitative analysis and analytical process, economic analysis, analytical process are such that often information cannot be, even if you do not have information can be generated by way of figurative studies. Okay, so if I see that a company has a profit line like this, which is roughly about, say, 25 degree, okay, in the line curve, it is a 25 degree. Suddenly you find that it has dropped down to 13 or goes up to 37. Now you can understand that there has been a price hike or price jerk. Now, this hike and jerk is definitely an extraneous influence of something others. So you can imagine that a price sensitive information must have been generated. Now, I personally, I have been in a research, and we found that the research done by some famous India broking house, um, and it is now sold also in the market, about the character of the 100 best traded shares in the share market. So 100 best companies traded in the share market, their shares have been studied over a period of time, and that study shows that tomorrow what is going to happen, day after tomorrow what is going to happen, whether it is going up or coming down. Now this is studied thoroughly, and the research, based upon that research, foreign direct investment is entering into the country, because the external broker, the broker of the London Stock Exchange, who are advising the foreign investors to come to India through Mauritius route or direct route, directly or through indirectly. Okay. Now they are actually offering the price based upon that study. Now, sometimes it is extremely difficult to distinguish that this information is not price sensitive, or even if it's price sensitive, even if it is price sensitive, it doesn't fall under that insider trading information, insider trading prohibition, because it is completely based upon draft figuratives. Okay. Now, say for example, when coronavirus was attacked, I do not know how many of you know that a company studied the impact of coronavirus on steel, and steel shares are going to be down like this. It is studied, and this information was not published in the newspaper. So it is not a kind of an information that is available to the market, whole market. It was only available to two companies who are dealing with stocks and shares of steel market, including one who is a foreign investor. Do you understand? Now, therefore, today, what you say, price sensitive information, is not simply that the resolution of a board meeting, which is price sensitive, definitely. Resolution of a board meeting, retirement of a director, or appointment of a managing director, or this and that, which are price sensitive information generated in the board of directors. And board of directors are the people who are insiders, and they are prevented from trading. Do you understand? And that is your line of action. Today, the idea is often we say idea is not an intellectual property. Today we are using idea, and idea is generated through the quantitative analysis, and economists are studying completely through that to see the market going up or coming down. Now that there is a market, in the market, there is a coronavirus. Everybody knows it, but everybody is not supposed to know the impact on a share market. Do you understand that? So price sensitive information generation is not simply on the people who are insider. It may be from outsiders also. Those outsiders, this distinction between artificial distinction between outsiders and insiders is really, I think, is not working today. In the present world, it is not working today. Now, it was working when it was Rajat Gupta. In Rajat Gupta's period, you require a broker, you require a telephone, you require, as Marcos very rightly said today, if you make a phone call, everything is available. See, everything is available not on investigation only. Everything is available to China. You know that Chinese, they are amassing the information system of the consumers in India. consumers pattern, consumers behavior in India. So consumers behavior in India in the stock capital market, it is not known to you, it is known to them. Now we say, now what is the, say for example, I have gone to the bank for making a loan, and I am a public limited company, my shares are in the traded, I am listed company, and I have taken loan against the securities of my building, plant, machinery. And we find that the market, global market is sliding down. Now, global market sliding down over a period will be a kind of straight line like this. It will be sloping like that. Now, if you see coronavirus sloping down due to coronavirus, it is whooping degree of almost 80, 82, 83%. Market has fallen. Do you understand? So if I can project that, I am a market advisor. I advise my client, do buy this at this time, to sell at this time. Now this, therefore, price sensitive information, which is generated inside, and therefore insiders are prohibited. What is the present day law? This law says that A, if you are an insider and you have a price sensitive information, you cannot participate in the market. You cannot buy, you cannot sell. Now, it is not a complete prohibition. They say you can buy and sell, but there has to be a trade policy, a trade pattern, a trade plan, trade plan, which you have to submit to the authority. A trade plan you have to submit to SEBI. SEBI compliant officer, after looking at all those, now he may require you that the price sensitive information must be disclosed. And you can trade, your opening day of the trading begins not before 12th day of the ending day of the financial year market, and not before, after 2 days of the financial market in the next financial year. Do you understand? This is the window given to you. So you are also given a trade facility with the information in 2 ways. Either you can keep the information, still trade, or you have to give the information publicly. You have to give the information publicly, disclose it publicly and trade. But your window will be this. If you violate that, then in the case, as Marcos also said, that you cannot come down as a director, you cannot be director appointed for next 7 years. For next 7 years, you cannot hold the position of any corporates. Okay. So it is almost like that, you know. I mean, US situation and Indian situation are almost similar. Is going in tandem. I think that if we have that case, 2 important issues are there. One issue is called Code of Fair Disclosure. What is that Code of Fair Disclosure? That if you are in a board of directors of a company, the board of director shall make a code, and this code has to be submitted to the authorities. That suppose the authorities are on a SEBI, the other one is the RBI. If it is say ADR, GDR, if it is foreign direct investment, indirect investment, you have to give to the Reserve Bank as well. Now it says that this fair disclosure means what? What would mean a fair disclosure? Supposing, as Marcos was saying, if I retire, if I want to retire after serving a company for 10 years, 12 years, obviously there shall be a kind of shake in the market. Or a market, capital market sneezes, capital market shifts, oscillates with the sneezing of your prime minister. Indian capital market is very small compared to European market. Indian capital market is small. Even today also it is small. Though we are achieving for $5 billion economy, $5 trillion economy, but still our capital market investment is not big, small. Now that's why it is said, smaller the market, unorganized the market, there will be wider fluctuation of the market, there will be wider invasion of insider trading in the market. That's why I initially started saying that in India in 2000, there was only insider trading, there was no outsider trading. Today, this thing is not like that, because stock exchanges were corporatized, brokers are all enlisted with this, brokers, jobbers, advisors, all the intermediary functions, they are registered players, but still there are many unregistered players. Many unregistered players in the market. They are not insider even today. So unless the law has very widely covered, saying that anybody having information, inside information, is an insider. Our insider information, it says that if any person have access to price sensitive information, he is an insider. You follow? So it is so I mean, what should I say? Anachronic, so compulsive, so overbearing, so jittery. If I have an information, I become an insider. Now, fair disclosure, code of fair disclosure has to be drafted by the board of directors. That means any decision that the board takes. Now, board members, management, and those who have access to the board resolution, like secretary, like secretariats, all members of the secretariat of a company, they all have the access to the board resolutions. How do they keep the information closed? So board has to formulate and publish the code of disclosure, and you have to see that this publication, code disclosure, who shall monitor? There has to be a monitoring responsibility. The managing director or CEO shall scrupulously monitor, and there shall be a compliance officer. There shall be a senior compliance officer who shall submit the compliance report on every tri-monthly, every quarterly before the board of directors. Followed. So this is one, fair disclosure. Now this fair disclosure is at a higher echelon. Then there is a code of conduct. The code of conduct of the entire corporate staff shall be prepared by the managing director or the CEO, and that has to be approved by the board of directors, and has to be also notified to SEBI and the RBI, as the case may be. And that conduct, now this conduct, if you do not follow, it becomes a misconduct. Misconduct, misappropriation. Marcos said misappropriation. In India, the thesis is completely valid. Misappropriation. You are misappropriating the fact because the conduct rule says this. So detailed conduct rule about the inside, if you have access to inside information, and most of the corporate staff, they have access to inside information, including the peons. Therefore, you have for every of them how they should behave and how you will monitor, who will monitor, how you will monitor, day-to-day monitoring of inside information disclosure, non-disclosure, inside information being kept confined to only the companies. Now, these are to be also monitored, and these are to be regulated by the compliant officer of the company. Now, every year, this compliance report has to go to the board. I mean, SEBI, Security Exchange Board of India. I think I do not know. My time is gone, perhaps. There are obviously 2-3 things more important. One is called institutional mechanism to prevent insider trading. This is extremely important. But I think that public limited company was in liquidation. This is the case going on. A public limited company goes on liquidation. and it is a subsidiary company. It is a private company, but since you know subsidiary of a public company is a public company. Subsidiary, the holding company, which is a public limited company and a listed company, that company has to buy some shares. That company has already shares about 53% of the capital of the subsidiary company. So if they buy some more shares, it would become 55% of the subsidiary company. That means 2% will increase. Am I clear? Now they are buying, they propose to buy it. Company in that meeting proposed to buy it. So long it was proposed to buy, it was inside information. Now the question is, India has got 3 levels of enforcement mechanism. One level, first level of enforcement mechanism is called that you can take advance ruling. You can give the case, this is the case, and for that, say we have violated. So please, whether we have violated or not, please give an advance ruling. If we have violated, we think you violated, but you also think you violated. In that case, we are ready to, what they say, we are ready to pay your agreed fine. That is called composition of the fine that you impose and I pay. Okay. And now this is one. Now the second level, which is now this case is second in the second level. In the second level, you are applying to the SEBI senior management. SEBI senior management, after reviewing the whole case, they say whether you require to fulfill the conditionalities laid down in the institutional mechanism of insider trading prohibition or not. So, and then also they say whether you are also responsible to go to what is known as takeover code, compliance of a takeover code. Now, the question here is that, is this a price sensitive information? Is this a price sensitive information about the company's share sale? If it is, then do we is it also affecting the takeover code? If it is not affecting the takeover code, what actions need we take? So this is the case. I repeat again, there is a subsidiary company which is a private company, but subjected to, it is its holding company is a public company, so that it is also a public company. It is under liquidation. Appointment of liquidator is there. Liquidator is now asking the SEBI, its middle level, that means administrative advice from SEBI. That is the second level, preemptory condition, that this is the resolution taken by the holding company that they will buy shares of this company, or so many shares of this company, their subsidiary company, from the liquidator. Okay, their percentage of holding was 53%. As a new buy, it will come to 55%. So the question is whether this information is price sensitive information to the shares of the holding company in the capital market. That is number one. If it is a price sensitive information, should we give, number two, disclosure? Should we come and disclose that? Or it is not required to be disclosed, we can buy. Because we can buy outside the market, off the market buy, not on the market buy, because it is only a liquidation process. Off the market buy. Third,
so may I interrupt?
That if it is price sensitive, yes.
So
yeah, you said something.
Yes, sir. I was just saying that we are running short of time. So if you would like to take questions from
I know.
the students. Yes.
Okay, I take questions from the students.
Yes. So, sir, there was a question from one of the students. It was in reference to what Marco talked about, price-sensitive information as it should be precise in EU. So he asks, when any information is not confirmed, but someone has information about the same, and she invests in the same suddenly after the price is surged, and she earned enormous profits out of it, will the non-confirmed private information be called as insider information or not?
By non-confirmed information, you mean, I assume, either an information that the issuer, the company itself, has not acknowledged or confirmed, or you might be referring to an information that is uncertain whether it's true or not. I imagine. Now, if you want to specify, I'm happy to hear. But I guess you're thinking about the first situation. Now, what I would say in that respect is that the fact that the issuer confirms, acknowledges, recognizes that information as true and correct is not in itself relevant to determine whether the information is inside information. It's a very factual analysis. The fact that formally it's confirmed or disclosed or commented by the issuer is not relevant. As a matter of fact, as you can imagine, in principle, most inside information being confidential, they have not been specifically confirmed in any kind of formal and somehow public setting. So if that is the question, I would say that is not relevant. It might be obviously more tricky, the question, if you are on the other hand saying, well, what if the information is substantively potentially not true? And in that case, if the information is not true, I don't think it would be precise enough, so probably wouldn't be inside information. However, that also might become tricky, because on the one hand, you start bordering potentially with what we call manipulation of the market. And on the other hand, there are some, for example, think about it, it's a different story, but I'm sure you are familiar, you have heard the recent GameStop story now with this. Now, some commentators say, well, the very fact that a certain number of investors acts based on the expectation of something might in itself become inside information. But that's, again, it's a different story. And if the question is simply if it's required that the issuer somehow takes a position on the information, I wouldn't say so.
Okay, so sir,
Can I add to what Marcus said? Yeah, I like to add, in India, position is slightly different. When she said private, first thing is that she got the information from what source? Is it a private source or it is a public source? Is it material? What is material is, now who has given this, where from she has collected this information? Is it collected from the connected person of the insiders? It is based upon the information supplied by connected person of the insiders. In that case, in India, she shall be subjected to insider trading information. So profit, total profit, 3 times the profit, or up to 25 crores penalty can be imposed on her. But supposing I said, now she is based upon some calculations, her sixth sense, okay? A lot of people buy and sell on sixth sense. In those senses, those things, she is not coming under the insider trading at all. In India, any price sensitive information, inside information, price sensitive inside information, that if you have, then you also become insider. Am I clear?
Yes, sir.
Okay.
Okay. One more thing I wanted to ask to Professor Marco. there were issues in regard to insider trading through social media platforms in India, and there was a WhatsApp channel by the name uh, Chatterbox, wherein details regarding profits of the company were provided to the tune of, say, 2 decimal points, and it was so accurate. And then the regulator felt helpless how to regulate this, and there were cases pending before Jharkhand High Court, I remember. And then it was discussed as to how we can regulate it. So, Marco, do you think there is any provision in European Union or in US wherein dissemination of price-sensitive information is regulated uh, on such digital media platforms?
It's actually a great question. I think that most legal systems are struggling somehow on with what approach to take, because on the one hand, social medias do resemble a sort of open forum or a sort of newspaper that accepts everything that people write. But on the other hand, they are also very different because they do have or might have such an impact that becomes in itself relevant. So right now, I wouldn't say that there are specific systematic provisions on how to treat dissemination through social media of information. There are some references, and for example, when we say that the issuer must make public and information must disclose, the typical tools are financial press. But more likely than not, nowadays, at least with some social medias, you can also argue that by putting something on a social media, you have made it public and you have reached, potentially the entire market or almost. So in that respect, for example, they might acquire a particular relevance. In terms of violating the law through manipulation, through dissemination of inside information that could not be disseminated, and so forth, social media would be irrelevant. I think to me at least, one of the most interesting questions, however, is whether those platforms are so pervasive and so common that writing something on them in itself acquires some kind of legal relevance, for example, in terms of price sensitivity, that is different from, not only simply saying to a bunch of friends, but to some extent also maybe to write an article on a traditional newspaper. And that is a tricky question because, again, GameStop is the perfect example. I don't know all the details of the case. I don't know the details of the case in India. But here's the thing. Let's say I write in a very popular social media, the prices of corporation X are going to go up and I want to invest. Or I just write, they're going to go up. And then I buy the shares. Is that an inside information? Have I created a sort of inside information in the sense that I was aware of the fact that I was about to disseminate this information? So it's not really an answer to your question, but I think we are all trying to figure out how to deal with that.
So there is one more question. I would first like Professor Mitra to answer this. A student, Shreyansh, is asking, regarding manipulation of the market, recently SEBI banned a financial news agency anchor and his wife. Both were banned for manipulation of the stocks by giving tips on their news channels, but many factors are involved in giving tips and actual price manipulations of stock prices. Will giving such tips also be considered as manipulation of stock prices?
Now, this is a very interesting question.
Yes.
Because when on media, where on news agency, we debate on some price sensitive information. Does it remain, information remains closed or it becomes open? The question is that, do you think that information remains closed or information goes open? It becomes public, or it remains still confined to only buyer and seller? Now, I think in social media case and this case, they have the same problem, issue is same. But this issue is more on human right. Because these platforms are public platforms, therefore, can I say that it is only private people who are buying and selling informations? Very difficult to say. Okay, very difficult to say, very difficult to hold. I think if the matter goes to not court, first they have to go to SEBI, and it is not, when they go to court on only on constitutional law, right? So they have to go to SEBI, and from SEBI they have to go to the adjudicators, okay, and then take it to appellate board, appellate tribunal. That is the way. But I think in all the cases, my concerted opinion is that it does not remain confined to, if it does not remain confined to only some buyers and some sellers, it is not an inside information which is traded. It is made open. It is not traded. It is open.
Thank you, sir. I'm afraid we are running very short of time. I would ask one of our students, Naman Sharma, to give vote of thanks.
Thank you so much, sir. A very good afternoon to one and all. At the outset, I'd like to extend my heartfelt gratitude to Professor Marco and Professor NL Mitra, sir, for taking out their time and providing us with insights into the very important aspects of the securities law and a comparative analysis of the law. It was indeed an enriching experience for all of us, sirs, and the insights into the legal perspective shall certainly be fruitful for all of us in our future. I'd also like to thank our Dean and Director, Professor Dr. Purvi Pokhriyal ma'am, for giving us all the opportunity to be the part of such enlightening session. Thank you so much, ma'am. I'd also like to extend my gratitude to our faculty coordinator for this event, Professor Yash Pandey, sir, for ensuring all the modalities of the session. Further, I also extend my heartfelt thanks to the technical support team for providing us with such realistic experience in these tough times. At last, I'd like to thank all the participants for being an active and patient audience. Thank you, everyone. Have a great day. Thank you, sir.
Thank you so much. Thank you, Professor Mitra. Thank you, Professor Marco. It was indeed, we need, I think, longer duration to discuss about these intricate issues. Thank you so much for joining with us today for the session.
Now, let me also thank you all, and I apologize if I have maybe taken a little bit more than I was planned. I was maybe catched up with the discussion, but I also want to not only thank, obviously, the organizers and also the students that were patient enough, but especially Professor Mitra, because actually I learned a lot from his very clear and fascinating and charming explanation. And what is interesting to me is to really see these legal transplants and see the ways in which, for example, the Indian system, in certain things has its own original approaches, in others it resembles more closely Europe and US. And the nice thing about these things is that there's this sort of almost social and legal experiments now where we can benefit from each other's experiences. So thank you very much.
Thank you, Marcos. We learned also many things from you.
Thank you, sir. Thank you always for supporting us and being there with us. Thank you all.
Yes, I have distributed an outline.
Yes,
it has gone to you.
Yes, sir.
Okay.
Okay, sir. Thank you so much.
Take care. Have a good day.
Have a good day.
Thank you.